are there any red flags or things that you have seen hurt a person's request, even maybe unintentionally, for parenting time or decision making?
I would say,
Welcome, everyone. This is the Illinois Family Law Insider podcast, and with me today is partner Nina Kelly. Thanks for joining me today, Nina.
hi, Katie. Thanks for having me.
So, today we are going to delve into court standards, the evidence that's needed, and also protecting parental rights. So, specifically, we are going to figure out how courts get into the nitty gritty details and make decisions when it comes to not only parenting time, but also decision making, and what you as a listener need to know in order to protect your parental rights. So, first and foremost, Nina, can you tell us a little bit about what the courts look at in terms of standards when determining or deciding parenting time as well as decision making for parents?
Yeah. So both of them, it's called the best interest of the child, right? So, yes, it can be a little bit ambiguous, which is obviously why you have lawyers, because that's we argue about what the best interest is.
Yeah.
But it really comes down to the kid. A lot of people kind of make the mistake of saying, well, what's in the parents? They kind of frame it as what's in the parents' best interest, which the judge is not going to consider.
Absolutely. And then are there any factors within the statute that you could kind of flag for people or just give a little bit more context or detail? Like, what are best interests? Like, what really matters to people?
Yeah, so it's 602.5 and 602.7 are the two that kind of deal with decision making and parenting time, which technically they're different, Katie. And I don't know, there's a few differences, but they're pretty similar, right? As far as what
I think
the
if you like break down the factors, there's like two more for, I think, parenting time versus decision making, or it could be,
Mhm.
I would have to just double check. But one has like, I want to say 17 factors, the other has 15. But if you were to
Yeah.
compare the two, it's very, very similar.
Yeah, yep. Parenting time, I think, has 17 because they
Yeah,
have, the physical distance, for example, between the two parties' houses is something to
exactly.
consider for parenting time or for decision making.
Yeah.
Obviously, that doesn't matter. But the main ones, the wishes of each parent are considered. It's not going to be what decides. But if one parent is like, I don't want these kids, obviously that's going to be considered. Wishes of the child, sometimes people kind of depends on their age and why they want the way that they do. I don't know about you, Katie, but I've had a ton of clients say, well, my kid is going to say that, my kid wants to be with me. And it's like, well, great. That's not going to usually hurt you at all, but it's definitely not going to be a deciding factor.
I totally agree.
The biggest one in my experience that is going to be the driving force between if one parent is going to be majority is going to be who's been the primary caretaker the 24 months preceding the petition. So that's what I meant by sometimes maybe moms have an edge just because if they have been a stay-at-home mom, yeah, it's not the working parent's fault that they haven't been there. And it almost does feel like you're getting penalized for working. But it's again not about you, it's about the child.
Correct. And that stability, I think if there's been one primary caretaker for that 24-month period, I think a lot of times courts and maybe even guardian ad litems just kind of want to maintain that level of stability and security for the child.
Yeah.
Whereas, if you have two parents who have been actively involved in caretaking over that period of time, then I think that kind of lends itself to both parents actively continuing to be involved. Um,
Right.
and I think work schedule is one where like people, I think, underestimate how impactful a work schedule can be when determining a parenting time schedule.
I completely agree. The work
Yeah,
schedule, like if you know you're going to be in some sort of quote unquote custody battle that we don't call it that anymore, but colloquially
right.
we do, you have to get your work schedule in line with their school schedule or figure it out where you're going to be available, the times you want to be available. Because if one parent's not working and one parent's working, the other parent 99% of the time is getting those kids. And it could really hurt you. Even though if it's been the status quo and changing it during the case, yeah, it's better than not changing it at all. But if you can change it before, I think that would be a huge help.
I agree. Strategically, that would be the best.
Yeah.
Um, and Nina, tell us a little bit, do courts lean towards an equal parenting time schedule? Is there any presumption or preference for that over anything else? And what's been your experience with that?
There's not, pursuant to the statute, and there's not necessarily in practice. It kind of depends on your judge. Some judges kind of have tendencies, as well as if there's a third party like a guardian ad litem or a child representative, that third party attorney that's appointed to look into the kid's best interests. Those GALs and child reps oftentimes have tendencies too, depending on the case. And it just kind of depends. And that's also another reason you kind of like to have an attorney that has done this, because they might know, oh, well, this case, we might want to try to get this person in as the GAL because they know what they might tend to do.
And I feel like so much rides on that interaction that the party has with the guardian. Well, I feel that sometimes I think people don't value those interactions or those meetings the way that they should when it comes to strategy and how you can really kind of prepare for those ahead of time to have
Mhm.
the best kind of impact on your guardian, the best impact as possible, right? Given the facts and circumstances that you may not be able to directly control. Um,
Right.
but it just depends. It's on a case by case basis. I feel like that's one where you really can't predict how
Right.
the interaction is going to go, whether it's going to be good or whether it might not be so great.
Yeah, and I mean, it definitely is, it is common, right? It's not an uncommon thing to get a 50-50 schedule, but by no means should you go into it expecting that's what it's going to be, because that's
Exactly.
not how it goes. But as far as kind of back to what you were saying about what you wanna show, so typically, right, if you're I think we had addressed this in a different podcast, but if you don't have an agreement coming in, you're gonna go to mediation, 99% of the time. And if mediation fails, then a guardian ad litem or a child rep come into play.
Yep.
Because before that third party gets involved, you don't really evidence and stuff isn't really gonna help, right? Because if you're not coming to an amicable resolution, it doesn't matter what evidence you have because that hasn't come into play yet. But
Right.
if we are gonna be kind of fighting over it, you kind of wanna gather people off and say, "Well, what can I do to prepare?" It's like getting communication logs, prior, text screenshots, emails, make sure you're dating them, especially for the texts, showing their cooperation or lack thereof, or things that they've said, not to you. The judge really doesn't care if you guys hate each other and what people say to each other, if it doesn't involve the kids or the kids weren't there, but about the kids and about their lack of participation and stuff like that.
Yep.
Medical involvement, who actually was there for parenting time, et cetera, can be helpful.
And then Nina, what would you say? Are there any red flags or things that based on your experience, have seen hurt a person's request, even maybe unintentionally, for parenting time or decision making?
I would say sometimes people, if you withhold a child without a court order, it could unintentionally backfire, but it's actually a lot less common than people think. And I don't think it should be that way. I think, Katie, we've talked about this, where if people just withhold a child, like rarely do they actually get punished until there's a court order. And then you better follow the court order because there's going to be consequences. But I think judges just don't really like to go back in time that much when there wasn't a court order. And so people tend to say, "Oh, well, I'm gonna be nice and give him the kid even though I don't want to." It's kinda like, or her the kid even though I don't want to. It's like, or don't, because rarely are there gonna be consequence. There could be, but rarely is it actually gonna be used against you.
I was gonna say, like, I definitely would agree. I think that once a court order is put in place, that completely changes. But a lot
Mhm.
of times, people may think that that's going to just have this huge negative impact on them, and in all reality, I just don't. I haven't like experienced that,
Right.
um, and I've honestly been on the other end where I'm like, this should really matter, and then it's like
Mhm.
it doesn't. So
Yeah,
it
you try to bring it up and the judge
yeah,
is like, "Oh,"
they're
moves
like,
on.
oh. It is what it is, just water under the bridge. It's like,
Right.
okay. Anything else that you could flag, Nina? Anything else in your experience?
Yeah. Get off social media. My biggest pet peeve is when my client, which actually rarely doesn't happen anymore. I feel like used to happen to me more, but I think I kind of read them the riot act and I'm like, from now on, everything you do, pretend the judge is reading it, because
Exactly.
nothing hurts you more than having really damning social media posts or text messages that are, because they can put you on the stand and make you read it. It's like,
Cor
it's embarrassing and it's really hard to get out from under because you did it.
correct.
And then alienating behavior too, I would say is something just like coaching kids is something to stay away from. But obviously that kind of gets into things that are a lot more difficult to prove. Like text messages and social media is so the reason it's so easy to stay away from is because it's just don't do it. Proving alienating behaviors and everything is a lot more complicated and difficult. So I would still say still don't do it, but it's difficult to prove.
It is. It really is. And sometimes that's like some of the most frustrating cases where you do have a parent who is just unilaterally making decisions. And it's hard to manage with a client where, you're telling them, be patient, it'll be brought up. The guardian ad litem should care about this. But sometimes, unfortunately, similar to the other, thing we just spoke about, which is withholding a child without a court order, sometimes I found the same thing. Like sometimes these things fall flat, whereas clients or parties really are just fixated on it. And it
Right,
sometimes can honestly like hold people back from reaching resolutions, and they might get like hyper fixated on those things. And really, it's about the best interests of the
right.
child. So
Yeah.
it just, having to go back to that major factor, I think, or that main standard is always something we as attorneys should be talking to clients and parties about, and, or at least our party about. So
Right. Yeah, and I would say if it gets to the point too where, it is really, the judge isn't listening, that it's not in their best interest because of this, whatever the other parent's tactics, then we can get other professionals involved to help prove it. So it's not like we can't prove it, but it's always good to circle back to that.
exactly. I totally agree. And then when it comes to protecting parental rights, do you have any like tips, or what is, best advice that you could give someone they really kind of want to maximize and protect those parental rights?
Yeah, so I would say if you live together, so divorce or parentage case, either one, don't
Mhm.
move out of the house without the kids is the number one thing I tell people, even though you might want to. And if it's dangerous, obviously that's a whole different situation. But if
Correct.
otherwise, if you move out without the kids, you're basically giving the other parent the majority of the parenting time, and that becomes the status quo. And it's hard to disrupt the status quo. So that would probably be the first thing.
Or get a parenting plan, right? Like, get some type of
Right.
temporary parenting time, and then feel free to move out because 'cause you've
Correct.
got ordered
Once
time. Yeah,
100%. One unless there's a temporary order in place, then sure, separate because there's a court order that can be enforceable, and that kinda leads me to my second point, which is take your time, and if the other parent is withholding it, we need to hold them accountable. Don't just brush it off because you are under a microscope when you're in court.
exactly. I could not agree more. And are there any tools that you're aware of, Nina, to help kind of protect your role as a parent? Are there anything that you have in your mind in terms of what a parent can do to really protect that?
Yeah, there's a few. So the first thing I always wanna file unless my client has the kids and the other person is trying to get more time, then I don't need to file this, but a petition for temporary parenting time schedule, like we just talked about, is really important.
Yep.
If, like, again, we were just talking about if you're trying to prove alienating behaviors or really mental health issues that are going on, getting a custody evaluation. Or third, I typically am kind of known well, I like to file petitions for parenting time abuse, which is an enforcement petition when they're violating even temporary orders. Like it's I think it's important to hold people accountable when you're in court the first time, otherwise they're going to keep doing it.
Exactly, and if the judge doesn't know that they're doing these types of things, like, if nothing's filed, they will not know, and so you've gotta file things to make sure you're alerting the judge to the fact that, "Hey, this person's not following the court order," right? So,
Right. Yeah, for sure.
and then what would be your best advice to a person if they are coming up against false allegations? Or let's say someone is saying that they're doing something and it's just completely false. How would you best advise a client in that situation?
So my first thing to do is A, to gather any evidence you have contrary to what they're saying, right?
Yep.
B, obviously don't do what they're saying, right? Right? Like, don't react, because they're probably trying to get something out of you.
Yep.
But third, it's unfortunate because it can get expensive, but I want to get a third party involved. I want to get a custody evaluator. I want to get a guardian ad litem because it's going to be a he said, she said, and people get so frustrated, but the judge doesn't know what's going on. And I'm going to argue one thing, but guess what? The other side's going to argue the other thing. And so I can argue it all day. If we have proof, it will help. And sometimes that is enough. But otherwise, getting a third party involved can really help.
I agree. Kind of sift through the he said, she said. You have this third party who comes in, does a thorough investigation, makes recommendations, and then it just kind of sheds light on what's actually happening in the day to day.
Yeah, for sure.
So, Nina, have you ever had experience with a case where a parent's calm behavior under pressure helped them get more parenting time or decision making?
Yeah, 100%. So one of my first orders of business when I get a case that's what we call contested, right? So we're not agreeing after mediation. Sometimes I don't need a parenting app, but usually you do, right? You see that where this is going. So I want to get them on our family wizard or talking parents. And then I say, listen, our goal is to, because usually clearly there's a big disconnect. I say, we want them to look crazy, not you. So you do not engage with them, do not take any bait, keep it very pretend the judge is reading every single message. It's worked several times. I mean, then you can turn because you need proof, right? And then you can turn to the GAL and say, okay, look, this is how they respond to messages. Like they just go off the rails, they curse, they, do whatever. And then it really does give you the edge because one of the factors is your ability to facilitate a relationship with the other parent. And that's the factor that I turn to the most when it comes to these communications because it
Absolutely.
just it really blows up in their face.
Totally. And then have you had a case where maybe lack of documentation or maybe lack of overall evidence like hurt someone's chance at protecting their parental rights or maybe maximizing time with their child?
Definitely. I mean, I think, sometimes people say, well, I want to file a motion, but for parenting time abuse. And usually it is rare, Katie, I think, where you don't have any evidence because testimony is evidence. So I don't think it's really affected me that much in being able to hold people accountable, but the petitions are so much stronger when you have when I can say,
Yeah,
"Okay, this is your message. Look at their words," or "Look at this photo of them not there at the exchange point." It just makes it stronger. You can still do it, but it's much better if you have that evidence.
I could not agree more. It's like I don't think that it would like preclude someone. It doesn't maximize what you're able to accomplish in a case. That's
Exactly.
the distinction I would make with it.
Yeah,
Um,
for sure.
And then have you worked with a parent who maybe turned things around in court by showing really strong involvement or like historical child caretaking, even if the other side tried to make them look uninvolved or paint this picture that they've been the primary caretaker and other parent has been kind of non-existent?
For sure. I have half the cases I have right now, I think that's the case in which we prove I'm like, sometimes it's hard to prove because when you were living together as a married or as a, married couple are living together, it's like you did have your roles and things are now changing. So that's kind of my argument I make. If I
Yep.
had the maybe what's considered less involved parent before, I'm like, well, yeah, because they were staying in their lanes and now things are totally different. But then I'm
Right.
really getting on my clients about you better be at every doctor appointment. You better be being involved because then the GAL or whoever is or the judge can see, even if they weren't, or even if they didn't have evidence of being the super involved parent before, now they are.
Absolutely. I could not agree more. And then just to kind of wrap up our podcast today, Nina, together, any closing remarks or any, advice that you can give to someone who feels like they're being sidelined in a parenting plan or they're not, they're kind of being alienated or excluded from maximizing parenting time or decision making?
I would say if one has already been entered, you need to hold them accountable and take them back to court. I mean, it can be a pleading on its own. People maybe don't know that like even if you're not trying to modify anything or you're not having, there's nothing else pending in court, you can literally come back to court just to hold them accountable for violating the parenting plan. There's a bunch of different things you can get from that, whether it be makeup time, they might have to pay sanctions, they could pay your attorney's fees, they might have to take another parenting plan, whatever it is. But to hold them accountable, I think would be my number one thing because if, give them an inch, they'll take a mile.
Totally. And then if someone's starting up a case for the first time, whether it's divorce or parentage, what is the first thing you would recommend they do if there are child related issues involved?
So again, I would say it depends if they think it's going to be pretty contentious, start gathering your evidence would be my number one thing.
Yep. And then what is maybe one myth based on your experience that you have seen that courts maybe like people believe that courts want to see this, but really they don't?
I think it might be. over communication between the parties. Like they don't, I mean, it kind of depends on where your case is in this particular situation, but it's not like you need to be best friends. You just don't. You need to be businesslike. You need to communicate about the child and not be a jerk about it. But you don't need to be. People have this sometimes. Oh well, I have to, be nice and go to the birthday dinner with them or whatever. It's like no, you don't. You just need to follow an order or be cordial and co-parent.
I totally agree wholeheartedly. I think people have this kind of fixation on the dynamic between the two parents, and it
Mhm.
really, I think, can derail someone where it's like, really, the court just wants to know how are the kids doing, what is in the children's best interest, and just like you alluded to, it's like you need to have a business, relationship. It doesn't have to be, a perfect co-parenting dynamic because you may be getting divorced and that person may not want that, and you still just have to function though for the
Right,
kid's best interest. So
for sure.
totally agree. Well, thanks so much, Nina, for joining me today on the podcast, talking through parental rights and parenting time and decision making and just shedding some light on these topics. I really appreciate it.
Yeah. Thanks again, Katie.
And because the holidays are often the most emotionally charged time for co parents, with mistakes that can cause lasting damage, we're diving into the one custody misstep that hurts your kids more than you think. Watch this next to avoid it.